portion of advancement seminars. The thought of interpreting in legal settings, especially a courtroom, causes even the most experienced interpreter to feel nervous and intimidated. The complexities of legal language and the formality of most legal processes makes interpreting in a legal setting really challenging. Additionally, the participants in a legal setting are often very concerned and have a lot at risk: their property, their relationships, their freedoms, and so they're concerned about what the outcome of the event will be. In order to help you to gain skills and knowledge to feel more confident interpreting in legal situations, Advancement Seminars has developed a videotape series entitled Interpreting in the American Courtroom. You're about to view one of the tapes associated with the 6 videotapes. These tapes are designed to be used in conjunction with the resource workbook. Before viewing this tape, you should have completed the first 4 chapters of the resource workbook, which will provide you with the foundation information and principles to enable you to gain the greatest benefit from the tapes in this series. You should have also completed the introductory segment of the lesson which corresponds to the number on this videotape. 5 of the 6 student texts are interactive, meaning that 2 speakers will interact with one another using a question and answer format. One of the tapes is an expository text, where one speaker's message is conveyed in a continuous discourse. The format for each student tape is the same. First, the speaker or speakers will provide you with some introductory comments designed to give you some background information about the speaker, introduce you to their style of communication, and provide you with an overview of the legal situation or vignette in which they are involved. Next will be the legal vignette, designed to give you the opportunity to practice an actual legal text. You can view and practice the vignette as often as you like. Your practice activities will be guided by the workbook and the tasks you are required to complete. At the conclusion of your practice, refer back to the workbook for further instructions. Through increased knowledge, practice, and skill development, we can gain the confidence and skills necessary to effectively interpret in a variety of legal situations. On behalf of Advancement Seminars, I hope you find these tapes useful to you as you continue your skill development. Student text number 6. This vignette will be one of the most challenging for you to practice interpreting because of the nature of the legal text being addressed. The text is a set of jury instructions a judge is reading to a jury that has heard all the evidence in a criminal matter dealing with a felony crime of robbery with a firearm. The jury instructions must be read because they are standardized and must include very specific information. Because the instructions are in written form, the register is more formal than the other texts in this series. The goal of jury instructions is to provide the jury members with a summary of the evidence presented during the trial and specific directions about how they are to consider the evidence in relationship to the law. The fact that the instructions are written can be a benefit to the interpreter because the instructions can be reviewed in advance. For this reason, the resource book has provided you with a sample of the instructions. The jury member in this matter includes a deaf male. The judge and the jury member will now provide you with their introductory remarks.
Hello, I am Judge Robert F. Merrithew. This proceeding is occurring in a Superior Court and involves a felony act of robbery with a firearm. We are at the end of the trial, and I will be instructing the jury as to their responsibilities in determining the guilt or innocence of the two defendants charged in this matter. We have been in trial for several days, and the jury has heard all of the evidence presented by the state and by the attorneys for the two defendants. My job in instructing the jury is to summarize the evidence presented, explain the applicable laws in this matter, and direct the jury as to how to proceed in its deliberations. Instructions to the jury come from a standard bench book. The attorneys on both sides in this matter have assisted in determining which instructions apply in this matter. The jury that has heard this case involves one deaf juror. Members of the jury, these are the criminal cases wherein the defendant, Ralph Harris, and the defendant, Peter Johnson, are charged with a crime of robbery with a firearm, which is classified as a felony. To the charges, the defendants and each of them have entered pleas of not guilty. And under our system of justice, each is presumed to be innocent until the state of North Carolina proves his guilt beyond a reasonable doubt. A reasonable doubt, members of the jury, is not a possible doubt, for most things that relate to human affairs are open to some possible or imaginary doubt. But rather, a reasonable doubt is a fair doubt based on reason and common sense and growing out of some evidence or lack of evidence in this case. Your duty as jurors is to find the facts from the evidence in this case, and to those facts, whatever you find them to be, to apply the law given you during the course of these instructions. In arriving at the facts in the case, you may believe all, or part, or none of what any witness has to say from the witness stand, and you are the sole judges of the weight to be given the testimony of any witness that appears before you. It is your duty as jurors to recall, to consider, and to weigh all the evidence in the case, and to take your own recollection as to what the evidence was in the case. Now, members of the jury, as the court recalls, the state offered evidence which it tends to show that on October 5th, 1993, in the morning, George Marshall was managing a Phillips 73 store in Mecklenburg County. That while in the store, he felt a hand on his shoulder, and someone said, "Don't turn around." That a barrel of a gun was up next to his forehead. That he was told to crawl, and thereafter was struck in the head. That Harvey Wilson, came to the store and noticed outside a two-door red Toyota Sorrel automobile. With its engine running, that he saw no one in the vehicle. Upon entering the store, he was hit on the back of the head. That he partially saw a white male, shorter than he, with a stocking cap. That he heard someone in the back say, "Make him crawl to the back." That thereafter a report by telephone was made to the Mecklenburg County Police Department. That Marshall then found a change bag containing some $125 to $150 was missing. Together with a paper bag containing the sandwich labels and a paper bag containing cigarettes. That patrolman Kevin Lee, some 5 miles south of Phillips Store, met a red Tercel automobile heading south on Beatty's Ford Road. That he pursued the vehicle, which was being operated by a white male. With other movement in the vehicle. That he ran into a ditch and saw thereafter a white male running into the woods. That the red Tercel drove away. That he, Officer Lee, and Officer Long, and H.J. Russell went into the woods and found the defendant Harris and the defendant Johnson beneath an old wooden bridge. That Bushnell found a pistol. That Officer Lee talked with the Officer Bright by radio and was asked if a bank bag had been found. To which the defendant Johnson said it was in the car. And upon being asked what bag, stated the bag from the robbery. That Officer Long observed a beige-colored stocking in the defendant Harris's back pocket. That Dennis Parker approached the red Tercel coming south on Beatty's Ford Road, being occupied by 3 white males. That he saw a couple of paper bags thrown from the passenger window of the vehicle. And later retrieved them. That they contained cigarettes and the labels. That is some of the evidence